When you think of justice, you picture the lawyers, sharp in their suits, armed with arguments. You picture the judge, robed in authority, commanding the room. But there's another group in that courtroom, sitting quietly, off to the side. No one is really watching them. They don't argue the law, they don't preside over it. They decide it. On most days, they're just like you, teachers, business owners, or accountants even. But on some days, they walk into a courtroom and the weight of someone's fate rests entirely in their hands. This didn't happen by accident. The jury system was built on a single, radical idea: that justice is too important to be left only to the state, and that ordinary citizens, not just governments, not just courts, should hold the power to decide guilt, to decide innocence, to decide what is true. And this isn't just courtesy, it's a guarantee. The Sixth Amendment secures it in criminal cases, the Seventh in certain civil ones, written into the Constitution, non-negotiable. But why ordinary citizens? Why not just leave it to the experts? Justice was never meant to be a closed room. The system was designed so that the people it governs, everyday people, people like you, have a direct voice in it. Not just as subjects of the law, but as part of it. When a case goes to trial, it doesn't just land on a judge's desk. A group of people sit in that room. They listen to the evidence, they discuss it amongst themselves, and then they deliver a decision that is binding. In criminal and civil trials, this is called the Petit jury. It usually consists of 6 to 12 jurors in civil cases, while it is 12 in criminal cases. Then there's a different kind of jury entirely. The grand jury, 16 to 23 people. They never sit through a trial. They don't weigh guilt or innocence. Their job comes earlier. They decide whether there's enough evidence to bring charges in the first place. A gatekeeper, before the courtroom even opens its doors. Juries don't just appear. There's a deliberate process behind every seat in that box. It's outlined in the Jury Selection and Service Act. It starts with voter registration records, but if that pool doesn't truly reflect the community, courts go wider. Driver's license records, other public sources. The goal is simple: a pool that looks like the people it serves. The qualifications are straightforward. A juror must be a U.S. citizen, at least 18 years old, living in the district for at least a year, and able to read, write, and understand basic English. Those selected receive a qualification questionnaire, by mail or online, and they're expected to respond within a set time. But receiving that summons doesn't guarantee a seat in the jury box. The final group is chosen through a process called Voir. During Voir, both sides ask questions, not to test knowledge, but to understand the person. Can they set aside their biases? Can they be truly fair? If the answer is no, they're excused. Jurors can also be dismissed for hardship, which could be illness or financial strain. Each side can dismiss jurors without giving a reason, but they can't dismiss them based on race or gender. They're not looking for legal expertise. They're looking for something harder to find, someone who can listen without judgment, stay impartial under pressure, and decide based solely on what the evidence shows. Once seated, jurors hear the evidence, witness testimony, arguments from both sides. The judge explains the law that applies. When the trial concludes, the jury steps away from the courtroom, into a room no judge, no lawyer, no camera can enter. They deliberate, in private, until 12 strangers find their way to a single, collective decision. A verdict. Once a verdict is delivered in court, the jury's job is done. And just like that, they go back to their lives, the classroom, the shop, the desk. The jury system isn't a formality. It is built on something deeper, The belief that ordinary people should have a hand in decisions that shape their world. Not just the powerful, not just the trained, everyone. A jury makes decisions collectively. It brings different perspectives to the same set of facts, and it keeps that power with the people, not just professionals. But the system is not without its flaws. Bias, incompetence, underrepresentation. These aren't small critiques whispered on the sidelines. They're real, and they cut at the very foundation the system was built on. But these flaws point to how the system is run, not to why it exists. It has lasted centuries for a reason. The idea at its core remains sound. The goal was never perfection. It was participation. And that goal is still worth fighting for.
However, the jury system is really answering one question. Who should have the final say in American justice? Because justice was never meant to be a technical exercise, sealed off in courtrooms, handed down by professionals alone. It's a social contract, and the people it governs aren't just subject to it, they're part of it. Understanding the jury system isn't just relevant if you're called to serve. It matters for anyone who might one day walk into a courtroom, not as a juror, but as someone searching for justice themselves. And that could be any one of us. As the justice system continues to evolve, one question stays constant. How do we ensure that the jury system remains fair, effective, and truly representative for everyone?